The trial by jury as defined by Magna Carta. So yeah, let's get into it. That's gonna be fun. Much better than my last comment. So cut the camera. Back to it. That the trial by jury is all that has been claimed for it in the preceding chapter is proved both by the history and by the language of the Great Charter of English Liberty, or Magna Carta Libertatum in Latin, to which we are to look for a true definition of the trial by jury, and of which the guarantee for that trial is the vital part and most memorable part. So basically, the only important part of it. Section 1, the history of the Magna Carta, if you don't know about it. In order to judge of the object and meaning of that chapter of Magna Carta which secured a trial by jury, it is to be borne in mind that at the time of Magna Carta, the king, with exception immaterial to this discussion, but which will appear hereafter, was constitutionally the entire government, the sole legislative, judicial, and executive power of the nation. The executive and judicial officer were merely his servant appointed by him and removable at his pleasure. In addition to this, the king himself often sat in his court, which always attended his person. He there heard cause and pronounced judgment, and though he was assisted by the advice of other members, it is not to be imagined that a decision could be obtained contrary to his inclination or opinion. Judges were in those days and afterwards such abject servants of the king that we find that King Edward I, 1272 to 1307, fined and imprisoned his judge in the same manner as Alfred the Great among the Saxons had done before him, by the sole exercise of his authority. Parliament, so far as there was a parliament, was a mere council of the king. It assembled only at his pleasure, at the pleasure of the king, sat only during his pleasure, and when sitting had no power, so far as general legislation was concerned, beyond that of simply advising the king. The only legislation to which their assent was constitutionally necessary was demand for money and military service for extraordinary occasion. Even Magna Carta itself makes no provision whatever for any parliament, except when the king should want mean to carry on war or to meet some other extraordinary necessity. He had no need of Parliament to raise tax for the ordinary purpose of government, for his revenue from the rent of the crown land and other sources were ample for all except extraordinary occasion. Parliament, too, when assembled, consisted only of bishops, barons, and other great men of the kingdom, unless the king chooses to invite others. There was no House of Commons at that time, and the people had no right to be heard unless as petitioner. Skipping the footnote, I'm just going to stop here for a brief moment so you can read it if you'd like. Just pause the video if you need. Even when laws were made at the time of a parliament, they were made in the name of the king alone. Sometimes it was inserted in the law that they were made with the consent or advice of the bishops, barons, and other assembled, but often this was omitted. Their consent or advice was evidently a matter of no legal importance to the enactment or validity of the law, but only inserted, when inserted at all, with the view of obtaining a more willing submission to them on the part of the people. The style of enactment generally was either the king's wills and command, or some other form significant of the sole legislative authority of the king. The king could pass law at any time when it pleased him. The presence of a parliament was wholly unnecessary. Some say it is asserted by Sir Harry Spellman as an undoubted fact that during the reign of the Norman princes, every order of the king, issued with the consent of his privy council, had the full forces of law. And other authorities abundantly corroborate this assertion. The king was, therefore, constitutionally the government, and the only legal limitation upon his power seems to have been simply the common law, usually called the law of the land, which he was bound by oath to maintain, which oath had about the same practical value as similar oaths have always had. This law of the land seems not to have been regarded at all by many of the king, except so far as they found it convenient to do so, or were constrained to observe it by the fear of arousing resistance. But as all people are slow in making resistance, oppression and usurpation often reach a great height, and, in the case of John, they had become so intolerable as to enlist the nation almost universally against him, and he was reduced to the necessity of complying with any term the baron saw fit to dictate to him. It was under these circumstances that the Great Charter of the English Liberty was granted. The barons of England, sustained by the common people, having their king in their power, compel him, as the price of his throne, to pledge himself that he would punish no free man for a violation of any of his law unless with the consent of the peer, that is, the equal of the accused. The question here arises whether the baron and people intended that those peer, the jury, should be mere puppet in the hands of the king, exercising no opinion of their own as to the intrinsic merit of the accusation they should try, or the justice of the law they should be called on to enforce. Whether those haughty and victorious barons, when they had their tyrant king at their feet, gave back to him his throne with full power to enact any tyrannical law he might please, reserving only to a jury, the country, the contemptible and servile privilege of ascertaining, under the dictation of the king or his judge, as to the law of the evidence, the simple fact whether those laws have been transgressed. Was this the only restraint which, when they had all power in their hand, they placed upon the tyranny of a king whose oppression they had risen in arms to resist? Was it to obtain such a charter as that the whole nation had united, as it were, like one man against their king? Was it on such a charter that they intend to rely for all future time for the security of their liberty? No, they were engaged in no such senseless work as that. On the contrary, when they required him to renounce forever the power to punish any free man unless by the consent of his peer, they intended those peers should judge of and try the whole case on its merit, independently of all arbitrary legislation or judicial authority on the part of the king. In this way, they took the liberty of each individual, and thus the liberty of the whole people, entirely out of the hand of the king and out of the power of his law, and placed them in the keeping of the people themselves. And this it was made the trial by jury the palladium of their liberty. The trial by jury, be it observed, was the only real barrier interposed by them against absolute despotism. Could this trial, then, have been such an entire farce as it necessarily must have been, if the jury had no power to judge of the justice of the law the people were required to obey? Did it not rather simply implied that the jury were to judge independently and fearlessly as to everything involved in the charge, and especially as to its intrinsic justice, and thereon give their decision, unbiased by any legislation of the king, whether the accused might be punished. The reason of the thing, no less than the historical celebrity of the event, as securing the liberty of the people and the veneration with which the trial by jury has continued to be regarded, notwithstanding its essence and vitality have been almost entirely extracted for it in practice, would settle the question, if other evidence have left the matter in doubt. Besides, if his law were to be authoritative, authoritative with the jury, why should John indignantly refuse, as at first he did, to grant the charter, and finally granted only when brought to the last extremity, on the ground that it deprived him of all power and left him only the name of a king? He evidently understood that the jury were to veto his law and paralyze his power at discretion by forming their own opinion as the true character of the offenses that they were to try and the law that they were to be called on to enforce, and that the king's wills and command was to have no weight with them contrary to their own judgment of what was intrinsically right. The barons and the people having obtained by the charter all the liberty they had demanded of the king, it was further provided by the charter itself that 25 barons should be appointed by the barons out of their number to keep a special vigilance in the kingdom, to see that the charter was observed, with authority to make war upon the king in case of its violation. The king also, by the charter, so far absolved all the people of the kingdom from their allegiance to him, as to authorize and require them to swear and to obey the 25 barons in case they should make war upon the king for infringement on the charter. It was then thought by the baron and people that something substantial had been done for the security of their liberty. This charter, in its most essential feature, and without any abatement as to the trial by jury, has since been confirmed more than 30 times, and the people of England have always had a traditionary idea that it was of some value as a guarantee against oppression. Yet that idea had been an entire delusion, unless the jury had the right to judge of the justice of the law they were called on to enforce. Section 2. The language of Magna Carta. The language of the Great Charter established the same point that is established by its history, that is, the right and duty of the jury to judge of the justice of the law. The chapter guaranteeing the trial by jury is in these words, Latin. The corresponding chapter in the Great Charter, granted by Henry III, 1225, confirmed by Edward I, 1297, which charter is now considered the basis of the English law and constitution, is in nearly the same word, as follow, more Latin. The most common translation of these words at the present day is as follow. No free man shall be arrested or imprisoned or deprived of its freehold or his liberty or free custom or outlaw or exile or in any matter destroy, nor will we, the king, pass upon him nor condemn him unless by judgment of his peer and the law of the land. Or the law of the land. Latin. There has been much confusion and doubt as to the true meaning of the word Latin. The more common rendering has been, nor will we pass upon him nor condemn him, but some have translated them to mean, nor will we pass upon him nor commit him to prison. Coke gives still a different rendering to the effect that no man shall be condemned at the king's suit, either before the king in his bench, nor before any other commissioner or judge whatsoever. But all these translations are clearly erroneous. In the first place, nor will we pass upon him, meaning thereby to decide upon his guilt or innocence judicially, is not a correct rendering of the word. Latin. There is nothing whatever in these latter words that indicate judicial action or opinion at all. The word in their common signification describe physical action alone, and the true translation of them, as will hereafter be seen, is nor will we proceed against him executively. In the second place, the rendering nor will we condemn him bears little or no analogy to any common or even uncommon signification of the word Latin. There is nothing in these latter words that indicate judicial action or decision. Their common signification, like that of the word Latin, describe physical action alone. Nor will we send upon or against him would be the most obvious translation, and as we shall hereafter see, such is the true translation. But although these words describe physical action on the part of the king as distinguished from the judicial, they, nevertheless, do not mean, as one of the translation as it, nor will we commit him to prison, for that would be a mere repetition of what had been already declared by the word Latin. Besides, there is nothing about prison in the word Latin, nothing about sending him anywhere, but only about sending something or somebody upon him or against him, that is, executively. Coke's rendering is, if possible, the most absurd and gratuitous of all. What is there in the word Latin that can be made to mean, nor shall he be condemned before any other commissioner or judge whatsoever, clearly is nothing. The whole rendering is a sheer fabrication, and the whole object of it is to give color for the exercise of a judicial power by the king or his judge, which is nowhere giving them. Neither the word Latin nor any other word in the whole chapter authorize, provided for, describe, or suggest any judicial action whatever on the part either of the king or of his judge or anybody except the peer or jury. There is nothing about the king's judge at all. And there is nothing whatever in the whole chapter, so far as relate to the action of the king, that describe or suggests anything but executive action. But that all these translations are certainly erroneous is proved by a temporary charter granted by John a short time previous to the Great Charter for the purpose of giving an opportunity for conference, arbitration, and reconciliation between him and his baron. It was to have force until the matter in controversy between them could be submitted to the Pope and to other persons to be chosen, some by the king and some by the baron. The words of the charter are as follow, Latin. That is, know that we have granted to our baron who are opposed to us that we will neither arrest them nor their man, nor seize them, nor will we proceed against them by force or by arm, unless by the law of our kingdom or by the judgment of their peer in our court, until consideration shall be added. A copy of this charter is given in a note in Blackstone's introduction to the charter. Mr. Christian speaks of this charter as settling the true meaning of the corresponding clause of Magna Carta on the principle that law and charter on the same subject are to be construed with reference to each other. See 3 Christian's Black Note 41 note. Here's the footnote. The true meaning of the word Latin is also proven by the article of Great Charter of Liberty demanded of the king by the baron and agreed to it by the king under seal a few days before the date of the charter and from which the charter was framed. Here the words are used as these. Latin. That is, the body of a free man shall not be arrested, nor imprisoned, nor diseased, nor outlawed, nor exiled, nor in any other matter destroyed, nor shall the king proceed or send any one against him with force, unless by the judgment of his peer, or the law of the land. The true translation of the word Latin in Magna Carta is thus made certain as follow. Nor will we, the king, proceed against him, nor send any one against him with force or arm. It is evident that the difference between the true and false translation of the word Latin is of the highest legal importance in as much as the true translation, nor will we, the king, proceed against him, nor send anyone against him by force or arm, represent the king only in an executive character, carrying the judgment of the peer and the law of the land into execution. Whereas the false translation, nor will we pass upon him, nor condemn him, gives the color for the exercise of a judicial power on the part of the king, to which the king had no right, but which, according to the true translation, belong wholly to the jury. Latin. The foregoing interpretation is corroborated if it were not already too plain to be susceptible or of corroboration by the true interpretation of the phrase Latin. In giving this interpretation, I leave out, for the present, the word legally, which is in Latin, I guess, which will be defined afterward. The true meaning of the phrase Latin, the word judicium, judgment, has a technical meaning in the law, signifying the decree rendered in the decision of a cause. In civil suit, this decision is called a judgment. In chancery proceeding, it is called a decree. In criminal action, it is called a sentence or judgment indifferently. Thus, in a criminal suit, a motion in arrest of judgment means a motion in arrest of sentence. In case of sentences, therefore, in criminal suit, the word sentence and judgment are synonymous terms. They are, to this day, commonly used in law book as synonymous term, and the phrase Latin therefore implied that the jury are to fix the sentence. The word per means according to, otherwise there is no sense in the phrase Latin. There would be no sense in saying that a king might imprison, decease, outlaw, exile, or otherwise punish a man, or proceed against him, or send anyone send anyone against him by force or arm, by a judgment of his peer, but there is sense in saying that a king may imprison, decease, and punish a man, or proceed against him, or send anyone against him by force or arm according to a judgment or sentence of his peer, because in that case the king would be merely carrying the sentence or judgment of the peer into execution. The word peer or per in the phrase per Latin, of course, means precisely what it does in the next phrase, Latin, where it obviously means according to and not by, as it's usually translated. There would be no sense in saying that the king might proceed against a man by force or arm by the law of the land, but there is sense in saying that he may proceed against him by force or arm according to the law of the land, because the king would then be acting only as an executive officer carrying the law of the land into execution. Indeed, the true meaning of the word by, as used in similar case now, always is according to, as, for example, when we say a thing was done by the government or by the executive by law. We mean only that it was done by them according to law, that is, that they merely executed the law. Or if we say that the word by signify by authority of, the result will still be the same, for nothing can be done by authority of the law except what the law itself authorizes or directs to be done. That is, nothing can be done by authority of the law except simply to carry the law itself into execution. So nothing could be done by authority of the sentence of the peer or by authority of the law of the land except what the sentence of the peer or the law of the land themselves authorized or directed to be done. Nothing, in short, but to carry the sentence of the peer or the law of the land themselves into execution. Doing a thing by law or according to law is only carrying the law into execution. And punishing a man by or according to the sentence or judgment of his peer is only carrying that the sentence or judgment into execution. If this reason could leave any doubt that the word per or per is to be translated according to, that doubt would be removed by the term of an antecedent guarantee for the trial by jury granted by Emperor Conrad of Germany 200 years before Magna Carta. Blackstone cited as follow, 3 Blackstone 350. So there's Latin here. That is, no one shall lose his estate unless according to the custom or law of our ancestor and according to the sentence or judgment of his peer. The evidence is therefore conclusive that the phrase Latin means according to the sentence of his peer, thus implying that the jury and not the government are to fix the sentences. If any additional proof were wanted that jury were to fix the sentence, it would be found in the following provision of Magna Carta. A free man should not be amerced for a small crime, but according to the degree of the crime, and for a great crime in proportion to the magnitude of it, saving to him contentment, and after the same manner a merchant, saving to him his merchandise. And a villain shall be amerced after the same manner, saving to him his wainage, if he falls under our mercy, and none of the aforesaid amercement shall be imposed, or assessed by the oath of honest men of the neighborhood. Earls and barons shall not be amerced but by their peer and according to the degree of their crime. Pecuniary punishment were the most common punishment at that day, and the foregoing provision of Magna Carta showed that the amount of these punishment was to be fixed by the jury. Fines went to the king and were a source of revenue, and if the amount of the fine had been left to be fixed by the king, he would have a pecuniary temptation to impose unreasonable and oppressive one. So, also, in regard to other punishment than fines, if it were left to the king to fix the punishment, he might often have motive to inflict cruel and oppressive one. As it was the object of the trial by jury to protect the people against all possible oppression from the king, it was necessary that the jury, and not the king, should fix the punishment. Legally. The word legally in the phrase, per legally judicium, probably the extent of my Latin, perium suorum, so Latin, doubtless mean two things. One, that the sentence must be given in a legal matter, that is, by the legal number of jurors legally on panel and sworn to try the cause, and that they give their judgment or sentence after a legal trial, both in the form and substance as been had. And two, that the sentence shall be for a legal cause or offense. If, therefore, a jury should convict and sentence a man either without giving him a legal trial or for an act that was not really and legally a crime, the sentence itself would not be legal. And consequently, this clause forbids the king to carry such a sentence into execution, for the clause guaranteed that he will execute no judgment or sentence except it be by legally judicium, a legal sentence. Whether a sentence be a legal one would have to be ascertained by the king or his judge on appeal, or might be judged of informally by the king himself. The word legally clearly did not mean that the judicium, I'll say Latin, should be a sentence which any law of the king should require the peer to pronounce. For in that case, the sentence would not be the sentence of its peer, but only the sentence of law, that is, of the king, and the peer would be only a mouthpiece of the law, that is, of the king, in uttering it. Latin. One other phrase remains to be explained. Latin, by the law of the land. All writers agreed that this means the common law. Thus, Sir Matthew L. says, the common law is something called, by way of eminence, Latin, as in the status of Magna Carta, chapter 29, where certainly the common law is principally intended by those words, Latin, as appear by the exposition thereof in several subsequent status, and particularly in the status of 28 Edward III, chapter 3, which is but an explanation of that status. Sometimes it is called Latin, as in the status of Merton, cap 9, whatever that means, Latin. We will that the law of England be not changed. Sometimes, no, I read that. No, sometimes it is called blah blah Latin, the law and custom of the kingdom, as in all commission of Oyer and Terminer, and in the status of 18 Edward I cap, whatever that means, and Latin, diverse other, but most commonly it is called the common law, or the common law of England, as in the status cap in the status, and infinite more record in status 1 L's history of the common law 128. This common law, sorry for the gibberish, but I really can't read Latin. This common law or law of the land the king was sworn to maintain. This fact is recognized by the status made at Westminster in 1346 by Edward III, which commences in this matter. Edward, by the grace of God, to the Sheriff of Stafford, greetings, because that by diverse complaint made to us, we have perceived that the law of the land, which we by oath are bound to maintain. The foregoing authority are cited to show that the unprofessional reader, what is well known to the profession, that the law of the land mentioned in Magna Carta was the common ancient fundamental law of the land, which the king were bound by oath to observe, and that it did not include any status or law enacted by the king himself, the legislative power of the nation. If the term Latin had been included law enacted by the king himself, the whole chapter of Magna Carta now under discussion would have amounted to nothing as a protection to liberty, because it would have imposed no restraint whatsoever upon the power of the king. The king could make law at any time, and such one as he pleased. He could therefore have done anything he pleased by law of the land, as well as in any other way if its own law had been the law of the land. If his own law had been the law of the land within the meaning of that term as used in Magna Carta, this chapter of Magna Carta would have been sheer nonsense, inasmuch as the whole purport of it would have been simply that no man shall be arrested, imprisoned, or deprived of its freehold, or its liberty, or free custom, or outlaw, or exile, or in any other manner destroyed by the king, nor shall the king proceed against him, nor send anyone against him with force and arm, unless by the judgment of his peer, or unless the king shall please to do so. This chapter of Magna Carta would therefore have imposed not the slightest restraint upon the power of the king, or afforded the slightest protection to the liberty of the people, if the law of the king had been embraced in the term Latin. But if the Latin was the common law, which the king was sworn to maintain, then a real restriction was laid upon his power, and a real guarantee given to the people for their liberty. Such, then, being the meaning of Latin, the fact is established that Magna Carta took an accused person entirely out of the hand of the legislative power, that is, of the king, and placed him in the power and under protection of its peer, and the common law alone. That, in short, Magna Carta suffer no man to be punished for violating any enactment of the legislative power, unless the peer of or equal of the accused freely consent to it, or the common law authorized it. That the legislative power of itself was wholly incompetent to require the conviction or punishment of a man for any offense whatever. Whether Magna Carta allowed of any other trial than by jury. The question here arises whether Latin did not allow of some other mode of trial than by jury. The answer is that at the time of Magna Carta it is not probable, for the reason given in the note, that Latin authorized in criminal case or any other trial than the trial by jury, but if it did, it certainly authorized none but the trial by battle, the trial by ordeal, and the trial by compurgator. These were the only mode of trial, except by jury, that had been known in England in criminal case for some century previous to Magna Carta. All of them had become nearly extinct at the time of Magna Carta, and it is not probable that they were included in Latin, as that term is used in their instrument. But if they were included in it, they have now been long obsolete, and were such as neither this nor any future age will ever return to. For all practical purpose of the present day, therefore, it may be asserted that Magna Carta allowed no trial whatever but trial by jury. Whether Magna Carta allowed sentence to be fixed otherwise than by jury. Still, another question arises on the words Latin, whether in case where the question of guilt was determined by jury, the amount of punishment may not have been fixed by Latin, the common law, instead of its being fixed by the jury. I think we have no evidence whatever that at the time of Magna Carta, or indeed at any other time, Latin, hold on, scrolling. The common law fixed the punishment in case where the question of guilt was tried by jury, or, indeed, that it did in any other case. Doubtless certain punishment were common and usual for certain offense, but I do not think it can be shown that the common law, the lex terra, that's Latin, which the king was sworn to maintain, require any one specific punishment or any precise amount of punishment for any one specific offense. If such a thing be claimed, it must be known, for it cannot be presumed In fact, the contrary must be presumed, because in the nature of thing, the amount of punishment proper to be inflicted in any particular case is a matter requiring the exercise of discretion at the time in order to adapt it to the moral quality of the offense, which is different in each case, varying with the mental and moral constitution of the offender and the circumstance of temptation or provocation. And Magna Carta recognized this principle distinctly, as before been shown, in providing that freeman, merchant, and villain shall not be immersed for a small crime, but according to the degree of the crime, and for a great crime in proportion of the magnitude of it, and that none of the aforesaid amercement shall be imposed or assessed but by the oath of honest men of the neighborhood, and that the earls and barons shall not be immersed but by their peer according to the quality of their offense. All this implied that the moral quality of the offense was to be judged of at the trial, and that the punishment was to be fixed by the discretion of the peer or jury, and not by any such unvarying rule as a common law rule would be. I think, therefore, it must be conceded that in all cases tried by a jury, Magna Carta intended that the punishment should be fixed by the jury and not by the common law, for several reasons. 1. It is uncertain whether the common law fixed the punishment of any offense whatsoever. 2. The word, Latin, according to the sentence of his peer, implied that the jury fixed the sentence in some case tried by them, and if they fix the sentence in some case, it must be presumed they did in all, unless the contrary be clearly shown. 3. The express provision of Magna Carta before adverted to, that no amercement or fine should be imposed upon freeman, merchant, or villain, but by the oath of honest men of the neighborhood, and according to the degree of the crime, and that earls and barons should not be immersed but by their peer, and according to the quality of the offense, proved that at least there was no common law fixing the amount of fine, or if there were, that it was to be no longer in force. And if there was no common law fixing the amount of fine, or if it was to be no longer in force, it is reasonable to infer, in the absence of all evidence to the contrary, either that common law did not fix the amount of any other punishment, or that it was to be no longer in force for that purpose. Under the Saxon law, fines payable to the injured party seems to have been the common punishment for all offense. Even murder was punishable by a fine payable to the relative of the deceased. The murder of the king even was punishable by fine. When a criminal was unable to pay its fine, his relative often paid it for him. But if it were not paid, he was put out of the protection of the law, and the injured party, or in the case of murder, the kindred of the deceased, were allowed to inflict such a punishment as they pleased. And if the relative of the criminal protected him, it was lawful to take vengeance on them also. Afterward, the new custom grew up of exacting fine also to the king as a punishment for offense, and this latter was, doubtless, the usual punishment at the time of Magna Carta, as is evidenced by the fact that for many years immediately following the Magna Carta, nearly or quite all statutes that prescribe any punishment at all prescribe that the offender should be grievously immersed, or pay a great fine to the king, or a grievous ransom, with the alternative in some case, perhaps understood in Hall, of imprisonment, banishment, or outlawry in case of non-payment. Scrolling slowly for the footnote, because it's a long one. You can pause the video if you wish to read it all. Judging, therefore, from the special provision in Magna Carta requiring fine or amercement to be imposed only by jury without mentioning any other punishment, judging also from the status which immediately follow Magna Carta, it is probable that the Saxon custom of punishing all or nearly all offense by fine, with the alternative to the criminal of being imprisoned, banished, or outlaw, and exposed to private vengeance in case of non-payment, continued until the time of Magna Carta, and that in providing expressly that fines should be fixed by the jury, Magna Carta provide for nearly or quite all the punishment that were expected to be inflicted, that if there were to be any other, they were to be fixed by the jury, and consequently that nothing was left to be fixed by Latin. But whether the common law fixed the punishment of any offense or not, it is a matter of little or no practical importance at this day, because we have no idea of going back to any common law punishment of 600 years ago, if indeed there were any such at that time. It is enough for us to know, and this is what it is material for us to know, that the jury fixed the punishment in all cases unless they were fixed by the common law that Magna Carta allowed. Scrolling slowly for the footnote, pause if you need. No punishment to be prescribed by status, that is, by the legislative power, nor in any other manner by the king or his judge, in any case whatever, and consequently that all status prescribing particular punishment for a particular offense, or giving the king's judge any authority to fix punishment, were void. If the power to fix punishment had been left in the hand of the king, it would have given him a power of oppression which was liable to be greatly abused, which there was no occasion to leave with him, and which would have been incongruous with the whole object of this chapter of Magna Carta, which object was to take all discretionary or arbitrary power over individual entirely out of the hand of the king and his law, and entrust only to the common law and the peers or jury, that is, the people. What lex terra, or Latin, did authorize. But here the question arises, what then did Latin, legum terra, hoping I'm pronouncing right, authorized by the king, that is, the government, to do in the case of an accused person, if it neither authorized any other trial than by jury, nor any other punishment than those fixed by jury? The answer is that, owing to the darkness of history on the point, it is probably wholly impossible at this day to state with any certainty or precision anything whatever that the legum terra of Magna Carta did authorize the king, that is, the government, to do, if indeed it authorized him to do anything in the case of criminal other than to have them tried and sentenced by their peer for common law crime, and to carry that sentence into execution. The trial by jury was a part of legum terra, Latin, and we have the mean of knowing what the trial by jury was. The fact that the jury were to fix the sentence implied that they were to try the accused, otherwise they could not know what sentence or whether any sentence ought to be inflicted upon him. Hence, it followed that the jury were to judge of everything involved in the trial, that is, they were to judge of the nature of the offense and of the admissibility and weight of testimony, and of everything else whatsoever that was of the essence of the trial. If anything whatever could be dictated to them, either of law or evidence, the sentence would not be theirs, but would be dictated to them by the power that dictated to them the law or evidence. The trial and sentence, then, were wholly in the hand of the jury. We also have sufficient evidence in the nature of the oath administered to juror in criminal case. It was simply that they would neither convict the innocent nor acquit the guilty. This was the oath in the Saxon time, and probably continued to be until Magna Carta. We also know that, in case of conviction, the sentence of the jury was not necessarily final, that the accused had the right to appeal to the king and his judge, and to demand either a new trial or an acquittal if the trial or conviction had been against the law. Such, therefore, of the Legum Terra of Magna Carta we know with reasonable certainty. We also know that Magna Carta provided that no bailiff shall hereafter put any man to his law, put him on trial, on his single testimony without credible witness brought to support it. Coke thinks that under this word, Latin believus, however, in this act is comprehended every justice, minister of the king, steward of the king, steward, and bailiff. And in support of this idea, he quotes from a very ancient law book called The Mirror of Justice, written in the time of Edward I, within a century after Magna Carta. But whether this were really a common law principle, or whether the provision grew out of that jealousy of the government which at the time of Magna Carta had reached its height, cannot perhaps now be determined. We also know that by Magna Carta, amercement or fine could not be imposed to the ruin of the criminal, that in the case of a free man is contentment or means of subsiding in the condition of a free man must be safe to him, that in the case of a merchant his merchandise must be spare, and in the case of a villain his wainage or plough tackle and carts. This also is likely to have been a principle of the common law, inasmuch in that rude age, when the means of getting employment as laborer were not what they are now, the man and his family would probably have been liable to starvation, and if this mean of subsistence had been taken from him. We also know, generally, that at the time of Magna Carta, all act intrinsically criminal, all trespasses against person and property were crime, according to lex terra, or common law. Beyond the point now given, we hardly know anything, probably nothing, with certainty as to what the legum terra of Magna Carta did authorize in regard to crime. There is hardly anything extant that can give us any real light on the subject. It would seem, however, that there were, even at that day, such common law principle governing arrest, and some common law form and rule as to holding a man for trial by bail or imprisonment, putting him on trial, such as by indictment or complaint, summoning and impaneling juror. Whatever these common law principles were, Magna Carta requires them to be observed, for Magna Carta provide for the whole proceeding, commencing with the arrest. No free man shall be arrested, and ending with the execution of the sentence, and it provide that nothing shall be done by the government from beginning to end unless according to the sentence of its peer or legum terra, the common law. The trial by peer was a part of legum terra, and we have seen that the peer must necessarily have governed the whole of the proceeding at the trial. But all the proceeding for arresting the man and bringing him to trial must have been had before the case could come under the cognizance of the peer, and they must therefore have been governed by other rule than discretion of the peer. We may conjecture, although we cannot perhaps know with much certainty, that lex terra or common law governing these other proceeding was somewhat similar to the common law principle on the same point at the present day. Such seemed to be the opinion of Coke, who says that the phrase Latin means unless by due process of the law. Thus he say Latin, but by the law of the land. For the true sense and exposition of this word, see the status of 37 Edward III, chapter or cap 8, where the word by the law of the land are rendered without due process of the law, for there it is said, though it may be contained in the Great Charter that no man be taken in prison or put out of his freehold without process of the law, that is, by indictment or presentment of good and lawful man, where such deed be done in due matter or by merit, original of the common law, without being brought in to answer, but by due process of the common law. No man be put to answer without presentment before justice or thing of record, or by due process, or by writs original, according to the old law of the land. The foregoing interpretation of the word Latin are corroborated by the following status enacted in the next century after Magna Carta, that no man from henceforth shall be attached by any accusation, nor forejudge of his life or limb, nor his land, tenement, good, nor chattel, seized into the king's hand against the form of the Great Charter and the law of the land. Whereas it is contained in the Great Charter of the Franchise of England that none shall be imprisoned, nor put out of his freehold, nor franchise, nor free custom, unless it be by the law of the land. It is accorded, assented, and established that from henceforth none shall be taken by petition or suggestion made to our Lord the King, or to his council, unless it be by indictment or presentment of good and lawful people of the same neighborhood, where such deed be done in due manner, or by process made by writs original at the common law. Nor that none be put out of his franchise, nor his freehold, unless he be duty brought into answer, and for judge of the same by the course of the law, and if anything be done against the same, it shall be redress and holden for none. That no man of what estate or condition, here we go. Let's start again. That no man of what estate or condition that he be shall be put out of land or tenement, nor taken, nor imprisoned, nor disinherited, nor put to death without being brought in answer by due process of the law. That no man be put to answer without presenting before justice or matter of record, or by due process and writs original, according to the old law of the land, and if anything from henceforth be done to the contrary, it shall be void in law and holden for error. The foregoing interpretation of the word Latin, that is, by due process of the law, including indictment, has been adopted as the true one by modern writer and court, as for example, by Kent in the Supreme Court of New York. The Fifth Amendment to the Constitution of the United States seems to have been framed on the same idea, inasmuch as it provides no person shall be deprived of life, liberty, or property without due process of the law. Whether the word vel should be rendered by or by and, having thus given the meaning, or rather the application, which the word Latin will reasonably and perhaps must necessarily bear, and it's proper to suggest that it has been supposed by some that the word vel, instead of being rendered by or, as it usually is, ought to be rendered by and, in as much as the word vel is often used for and the whole phrase Latin which would be read unless by the sentence of its peer and the law of the land, would convey a more intelligible and harmonious meaning than it otherwise does. Blackstone suggests that this may be the true reading. Also, Mr. Allen, who says, Latin. Several explanations had been offered of the alternative clause, which some have referred to judgment by default or demurrer, other to the process of attachment for contempt. Certainly, there are many legal procedures beside trial by jury, through which a party's good or a person may be taken. But one may doubt whether these were in contemplation of the framer of Magna Carta. In an entry of the Charter of 1217 by a contemporary hand preserved in the Town's Clerk Office in London, called Latin, more Latin, and various reading, more Latin, occurs. Blackstone chapter, page 42-41, and the word vel is so frequently used for L, et, a, okay, I don't know, that I may not wholly free form a suspicious that it was so intended in this place. The meaning will be that no person shall be deceased except upon a lawful cause of action found by the verdict of a jury. This really seems as good as any of the disjunctive interpretation, but I do not offer it with much confidence. Here's the footnote. Feel free to pause. The idea that the word vel should be rendered by and is corroborated, if not absolutely confirmed, by the following passage in Blackstone, which has been cited. Speaking of a trial by jury as established by Magna Carta, he calls it a privilege which is couched in almost the same word. Footnote. Long footnote. With that of the Emperor Conrad 200 years before, Latin, no one shall lose his estate unless according to the custom of our ancestor and the judgment of its peer. If the word vel rendered by and, as I think it must be, at least in some case, this chapter of Magna Carta will then read that no free man shall be arrested or punished, unless according to the sentence of his peer and the law of the land. The difference between this reading and the other is important. In the one case, there would be, at first view, some color of ground for saying that a man might be punished in either of two ways, according to the sentence of his peer or according to the law of the land. In the other case, it requires both the sentence of its peer and the law of the land, common law, to authorize his punishment. In this latter reading, if this latter reading be adopted, the provision would seem to exclude all trial except trial by jury, and all cause of action except those of the common law. But I apprehend that the word vel must be rendered by both and by or, that in case of a judgment it should be rendered by and, so as to require the concurrence both the judgment of its peer and the law of the land, to authorize the king to make execution upon a party's good or person. But in case of arrest and imprisonment simply for the purpose of bringing a man to trial, vel should be rendered by or, because there can have been no judgment of a jury in such a case, and the law of the land must therefore necessarily be the only guide to and restraint upon the king. If this guide and restraint were taken away, the king would be invested with an arbitrary and most dangerous power in making arrests and confining to prison under the pretense of an intention to bring to trial. Having thus examine it, sorry for destroying the language. So let's start again. Having thus examined the language of this chapter of Magna Carta, so far as it relates to criminal case, its legal import must be stated as follow. No free man shall be arrested or imprisoned or deprived of its freehold or its liberty or free custom or be outlaw or exiled or in any other manner destroy or harm, nor will we, the king, proceed against him, nor send any one against him by force or arm, unless according, that is, in execution of, the sentence of its peer, and, or, as the case may require, the common law of England, as it was the time of Magna Carta in 1215. Alright, let me put back the camera on my face. Only that. Only that. Yeah, I am completely dry after reading this. I'm gonna try to keep the final comment for chapter 2 as short as possible. I'm gonna first tell you though that I'm gonna read further in the book and see if it's required that I keep on doing this reading. But I must urge you to get this book. Once again, let me remind you, it's called An Essay on Trial by Jury. And do I have the reference here? Down at the bottom. By Lysander Spooner. It's an ebook, so if I could get it, you could probably get it if you inform your favorite spying apparatus that you're looking for that, namely Google. Yeah, I'm not doing any advertisement for crap. But now the comments. We have learned in this chapter very simply that if you cannot get a trial by jury, you don't have freedom. And if that jury itself is not composed of your peer, you don't have any freedom. And if these peers cannot judge of the validity of the law that they're trying to inflict upon you, or the accused, still you get no freedom. We also learn, on the other hand, that trial by government is deeply unfair, or can easily be turned into an unfair thing at any corner. So basically, in 1215, these people understood that they had to take the power out of the government, except to be executant of the common law or law of the land. And of course they left them with the legislative power and executive, but the judiciary was to remain in the hand of the people, for them to invalid any law that was unlawful or not according to their wish or to the law of the land. And it's utmost important that if 800 years ago those people understood that, and we don't today in Canada, we're fucked. So let's take it back, and that's exactly why I've organized a grand jury in 2015. Not only did we put the now delinquent or criminal organization that we had to judge at the time, but let me remind you that the accused in the bench was the law, and it was rendered null and void. And by the way, since we figured out that there's been a coup d'etat, all the law that these criminals have written are unlawful. They're null and void. They're non-existent. They still may be there. The book still may be there. They're still in assembly, but it is all highly criminal and utmost illegal. So yeah, Canada currently has no valid government and no valid law, and well, even though it's insanity in the street, I mean, we're not in a civil war. People are not taking at each other's throat. They're not fighting with guns and whatever they could invent to fight with. That proves that we're a fairly peaceful nation, even without a lawful government and any valid legislation. And even if we didn't have any, people would not go into or descend into civil war. So we can easily self-govern. and live without those people. But I mean, even then in 1215, they kept the government, they kept their king. We could do the same, only we have to hold them accountable. So I'm reading all of that to teach you by my reading and written in this book that the power is in your hand. The power is not, has never been, and will never be in the proper hands of government. Fuck them. Fuck all their idea and their procedure. Power corrupts. Absolute power corrupts absolutely. This is why trial by jury is where the real power is, because it's only exercised for a short time for a specific case, and then it's passed on to the next group for another case and another circumstance and another act that has happened. So if we all share the load of shit, I mean, it's probably easier for each one of us to carry our part or our share. I know for one that grand jury in 2015 was fucking heavy because I carried it alone, even though I was not alone in the trial itself. The creation of it, the setup of it, and the conduction of the trial itself, I was the only one who had trust in it. All the other people that were there for the show. Honor to them because they still put their courage to come and participate. But honestly, to this day, of those present at the trial, at the grand jury of 2015, there's only one other person, which is Angèle Prince, which has understood the power of it. And both of us today, 5 years later, do not understand. I speak mainly for myself, but I know it's true of Angèle too. Do not understand the extent of the importance of that grand jury, but I can guarantee at the very bottom, at the very least, that it was fucking important. It was absolutely necessary that we did that. We had all the rights, and I hate using that word if you know me. We had all the right, but utmost the moral duty and obligation of doing so and keeping in check the bastard that thought we're our master. Well, I got sets of 2 words for any bastard who thinks he's my master. Fuck you. Nothing you can write, say, do, think will be the master of me unless I create a prejudice to someone else willingly. That means I have plan and then I'm going to act upon that plan. That is a crime. Because it needs not only the act, but it needs the intent to be a crime. Both of it in any criminal case. And their criminal code that they've written, it says on the title, criminal code. Who uses it? These criminal fucking court every day. These criminal bastard lawyer that should not exist. Use it every day. Why? Because they're criminal. They're pirates at the very least. But pirates are criminal. They live upon other people's labor. They steal and lie. And that's exactly what the so-called fucking government does. Because they're not the government. Oh, Your Honor, the judge. He's not a judge. He's a part of the crook gang. Oh, I'm a cop. Well, you're part of the crook gang. So fuck you. And your criminal code, you can shove it up your ass. Twice. And it's this fucking thick. Nobody can understand it. This is why the importance of trial by jury. People who will watch that. If I ever so choose to publish and if I can. So, yeah, I'm pretty dry after all of this. I implore you, take it back. Because the other way is nasty, ugly. It'll require a stream of blood, tears and sweat and pain and suffering. To an extent that cannot be described. Our ancestors have already suffered and sweated and bleed for us to be able to tell our stupid fucking rulers who think they're our government to go fuck themselves so deep that the Marian Trenches, which seems to be the surface of the earth compared to that. So, yeah, honestly, people of Canada, if you want it, it's yours. It's always been yours. It's never been theirs. They don't have any power but your stupid ignorance, and ignorance is no excuse today. If I could learn it, if our ancestor knew it 800 years ago, if they fought their own king for it, we can do the same. But today, the beauty of it, we really don't have to spill blood. Even though in the past, every generation had to spill blood to preserve their freedom and liberty, we, for the first time in 2020, could do it peacefully. And we don't even need prison to send these bastards where they belong. We don't need that. We just tell them to go fuck themselves. Oh, it's mandatory to wear a mask. Fuck you. Oh, it's mandatory that we put a stick into your nose to find out if you have a... Fuck you. Oh, it is mandatory to have a driver's license. Fuck you. Have I caused any prejudice with my driving? No, fuck you. Oh, it is mandatory to pay tax. Well, fuck you again. I'm not involved in commerce. Go and tax those fucking business who makes billions, Shell and the other, and Google and whatnot, fucking fuckbook, who didn't pay taxes in 10 years. Choke them until they can pay no more. Alright, so 1 hour, 15 minutes. Thank you very much for watching. I'm gonna think about reading chapter 3, which is additional proof of the right and duty of juror. It's probably going to be important that I keep on doing. Anyway, these are recordings because I can't publish them right away for lack of internet at this time. So I may as well continue. We'll see. So that was episode 2. I'm signing out. Thank you very much for listening to my reading and my ranting. And well, if I'm talking to myself, well, that's good. If anybody listened to that and understood, that's even better. But yeah, I don't care. It's still the truth, and it was me doing that, and I wish you everything you deserve, and I'll see you next time if I choose to do so.